is an appeal in the matter of Textor and Iconic Sports Eagle Investment.
Yes, Mr. Davis.
My lords, I represent the appellant along with Miss Timms, Mr. Green, Casey, and Mr. Perkins appear for the respondent. The only housekeeping would have been the reply skeleton, but I know you must have received that and read that, so I'm going to proceed straight into ground one.
Yes, you've discussed between you have your allocation of time.
Yeah, so rough 50-50. I'll save some time for reply, perhaps 15 minutes, 20 minutes, something like that.
Very good. And you know we encourage in this court that everybody on the team sheet should have a speaking role. Has that been taken account of?
No, I'm afraid it hasn't, well, because actually my main junior on the case, Mr. Lloyd, is not available. So Miss Timms has come in as a rather last-minute substitute. So yeah, I'm afraid it hasn't.
All right. Well, that's disappointing for us, but it is something we do encourage.
Yes, understood, my lord.
All right, off you go.
So ground one, going straight to the heart of the matter, which is obviously the wording of clause 3 of the put option agreement. That's at core bundle, page 138. So tab 10, Roman 1, page 138. And it's clause 3 that lies at the centre of ground 1, clause 3 headed completion. We know from clause 3.1 that the contract expressly envisages a meeting, a completion meeting, which is to take place in the registered office of the company, and that's relevant to some of the arguments later on. But really the heart of it is 3.2 and 3.3, and what we say is the sequence of obligations on completion. Now 3.2 we say is a straightforward mandatory obligation on Iconic shall deliver the specified documents. And that obligation is not expressed to be conditional on anyone else's performance or anything else happening. They simply have to tender those documents. Then over the page, clause 3.3, it's clause 3.3 is Mr. Textor's obligation, and the wording obviously we rely on is subject to Iconic complying with its obligations under clause 3.2, so that's the tender of the documents. JT shall on completion pay the aggregate option price to Iconic on or before the payment date. So that is, we say, the language straightforwardly of conditionality. If they tender the documents, then we pay the price. It does not say, clause 3.3 does not say, subject to Iconic being ready to tender the documents.
It doesn't say tender either, does it?
It says comply with their obligations under...
Well, it says deliver is the obligation.
Yes, I mean, 3.3 says comply with the obligations and 3.2 shall deliver.
Yeah, so it's important though, isn't it? It's that the obligation isn't the conditionality isn't merely on tendering; it's on delivering.
Yes, I wasn't trying to draw a distinction, but I see what you mean. And of course, the word is deliver, so I'll stick to deliver.
Yes, but it matters because your case is essentially that Iconic is obliged to hand over the documents.
Yes.
Which gives Mr. Textor complete control over the shares. And all it gets in return is a contractual promise to pay the price thereafter.
Backed up by various protections, and I'll come on to that in a moment. But what it doesn't say, and this is a contract drawn up by sophisticated parties, legally advised, what it doesn't say is on completion there shall be an exchange of payment and documents. An arrangement shall be made for such an exchange to take place. That's what it doesn't say. Rather, it's presented as a sequence of 2 steps, and that's why we say it contemplates sequential performance. Now, of course, that gives Mr. Textor protection, obviously, because he only ever has to perform second. But as I said a moment ago, the contract actually builds in a series of protections for Iconic as the party going first on our construction. I'm just summarising those briefly without going into the detail at the moment. Those are the default provisions in clause 4, which only apply on a Textor default, firstly. Secondly, the proxy provision in clause 5, which again only applies in a Textor default. And thirdly, there's a slightly different, but clause 7 is a lock-in for Mr. Textor from the point at which they serve their option notice. But clauses 4 and 5 are protections that only apply one way in their favour in the event of a Textor default. Now, all of that makes sense, we say, as a structure where they have to perform first and they need to be protected, as they are, against the risk of Mr. Textor not paying.
And those are only, both clause 4 and clause 5, are both only for the purposes, should Iconic choose to do so, to market the shares in accordance with the clause 4 procedure.
Well, 4 is a bit wider than that because it includes, for example, specific performance and 4A, 4.1a.
If under the default provisions, if on this scenario, the documents have been delivered, transferring title, and Mr. Textor then does not perform, why is there in 4.1 a right on Iconic to specific performance? It wouldn't be an entitlement to specific performance in that case, it'd just simply be a debt claim, wouldn't it?
Well, if they've delivered the documents, but the shares haven't been, I see your point, that they could just say, we are now owed the money. So
Not just
it
they
might
could,
be
there's nothing else. There's
unnecessary
nothing else to
spell
claim.
that. Yeah.
It's not a claim for specific performances. It's just a claim for debt.
Well, they might want, I mean, the actual transaction wouldn't have been fully completed because they would have delivered the documents, but the registration wouldn't have taken place. So they might say, well, we want a specific performance so we can finish the transaction. But, I mean,
They
at
wouldn't
worst,
be
it's unnecessary.
interested in those further steps if they haven't got the money. I mean, it would be it seems an odd idea.
Yes, I mean,
But in substance, the only thing they want at that stage is the money.
yes, but it might be that 4.1a is saying something that's unnecessary. I mean, quite a lot of my submissions are a tail wagging the dog type submission, which is it's 3.2 and 3.3 that tell you the sequence of the obligations. And when you look at lots of ancillary parts of the contract, there might be various oddities and things that are difficult to explain, but that doesn't alter the fact that 3.2 and 3.3 are themselves a clear sequence of obligations.
But forgive me, 3.2, 3.3 doesn't provide a sequence, does it? It just provides on the face of it a conditionality.
Yes, and we say that's the same thing. That because it's subject to Iconic complying with its obligations, it amounts to the same thing.
But what would normally happen on the completion would be that the vendor would tender the documents, possibly provide them to either its own solicitors would say they hold them to the order of the purchaser's solicitors, or they would actually be provided effectively an escrow,
Yes.
subject to the payment of the price. And that's what that means, doesn't it? Is that you pay the price once the documents are made available.
I think your Lordship is referring to a regime like the Law Society standard conditions, where that certainly is the normal approach under that particular regime.
Well, that's what this is providing for, isn't it? Is that once Iconic has made the documents available, the price will be paid.
Yes, once it's delivered them. Once it's
Well,
delivered.
it would be that the documents would be made available, and then there would be the solicitors would effectively exchange documents for price, wouldn't they?
I understand your Lordship's point, but my submission is that's not what this particular contract says. Even if that is the standard practice under the Law Society standard curve.
Well, it's consistent with that, isn't it?
Well, we would say no, because their obligation is expressed as a first stage mandatory obligation, as we would characterise it. On completion, they shall deliver. So it's not the same as the Law Society standard terms regime. And the parties could have used that if they had wanted to. these are sophisticated parties, and they didn't use it.
Thank you.
They used this wording.
Can I just come back to your point that the clause 4 mechanism is a sufficient
Yeah. Well, yes.
protection? Suppose that the share price is much lower than the option price, and that's why they want to exercise the put option, and they transfer the documents, and Mr. Textor doesn't pay. They might well conceivably not want to undertake the marketing process at that stage
Yes.
of marketing the shares. They might take the view that it would be better to wait for the shares to gain value. But on your case, in the meantime, it would be Mr. Textor, not Iconic, who could vote the shares, exercise all the governance rights, affect the value of the shares,
Yes.
and so on. So in those circumstances, clauses 4 and 5 wouldn't provide sensible commercial protection, would they?
Well, I'm not setting out to show that they provide every protection that one could want, or that they're a wise thing to have agreed from Iconic's point of view. In a sense, I'm aiming at a much lower target, which is they address this issue and they're one-sided, that apply only to a text of default. Now, whether they're sufficient, whether they're wise, whether they're comprehensive is another thing.
Well, one has to look at the commercial consequences and see
Yes.
whether the construction makes commercial sense. And I think
Yes.
what I'm putting to you is that your construction doesn't make much commercial sense. If the result is that Mr. Textor gets to keep and is able to vote and use the shares in the governance of the company in return for what is in fact merely a contractual obligation to pay, which he's not fulfilling.
Well, they could say he's in repudiatory breach and claim damages, and we'll come on to that. I mean, this is without prejudice to other remedies that would be available at law. No, I don't think anyone's suggesting this overtakes and replaces their other remedies.
Well, they could sue him for the price. So it's not, but it's a cause of action. It's not.
But I think my submission really, my lord, is we're not, even if one thinks, well, this isn't really a very good protection, we're not in the territory of illogicality or unworkability. We're in the territory of perhaps it wasn't very wise for them to have agreed this, which is not relevant ultimately.
Can I just ask you about that, unworkability or illogicality? Some of these protections are to do with a sales process taking place. And they clearly envisage that at that stage, Iconic will still be the owner of the shares, because it's going to be Iconic.
The holder, yes.
Whereas on your case, by this moment, Mr. Textor can get the shares into his name. He could do that immediately.
Yes.
So it does seem as though the parties, on your interpretation, are agreeing something which is senseless.
Yes, now I have that point very much in mind, and my answer is going to be, when I come onto it in the context of the judge's reason, firstly, that they would still hold the shares before the share transfer is registered, and in any event, the clause wouldn't be rendered unworkable on our construction.
Mr. Textor can procure the registration of the shares into his own name immediately,
Well, if
within seconds of completion.
yes, but they still hold the shares, and the word the clause uses is held.
In what sense do they still hold the shares?
Well, I'll show
If
you
your
the-
construction is right.
The provision in the model articles which says that you hold the share, the transferor holds the shares until registration.
No, but after
Yes, but-
registration.
Yes,
My lord's point is, immediately after this delivery of the various documents to Mr. Textor, he would be entitled to have the shares registered in his own name, and at that stage Iconic would not hold the shares,
yes,
which is what is contemplated by clause 4.
yes, but clause 4.2, I think it is not rendered unworkable, as the judge says, because that gives essentially a right to sell all of the shares, including Mr. Textor's shares.
Yes.
So it still works, it just contains unnecessary things. It's not frustrated in its purpose, it still works because they can sell all the shares, including the ones he started off with. So it doesn't actually make a difference.
How can they do that if they're not the registered holders?
Well, because they're given powers under the sales process. If just selling their original shares wouldn't raise enough money, they're given the power to sell some of his shares.
That's the proxy under clause.
Yes, exactly, and potentially that could include the whole aggregated shareholder.
But as a matter of construction, they wouldn't be, as clause 4 describes them, shares held by Iconic.
Well, as I say, it's in two parts. For some period, they would be, and that may help to explain the drafting. But anyway, our construction doesn't render the clause unworkable. It just has the consequence.
It's just drafting debris, you say.
Or it just leads to a curiosity of how it came about, but it doesn't render it unworkable in substance, which is what the judge said.
Right.
Now, well, it's important not to lose sight of the fact that, as you've seen, I mean, on the completion day, 26th of July 2024, Iconic did precisely nothing. There was radio silence on that day. Didn't produce any documents, didn't contact Mr. Textor to arrange a meeting or to discuss completion arrangements. It didn't proffer any draft power of attorney, discussion or agreement. In other words, Iconic didn't manifest any readiness to go ahead on that day. Now, they say there are reasons for that, but the fact is it didn't do anything on that day. So we say in those circumstances, the right analysis is ultimately simple. Everyone agrees the contract was still on foot on the completion day. No one terminated it, no one contends that. They remained obliged to perform under 3.2, and they didn't. And they're not ready to, as we'll come on to. Now, and as I said earlier, my lord, just by way of finishing this introduction, if these parties had intended a simultaneous swap or exchange, why not just say that? It's the easiest thing in the world to say that, and they didn't. Now, the judge's reasons, you'll have seen from the judgment, page 88. The bundle page 88, starting from paragraph 23. He gave a series of 6 reasons, then went on to make a few additional observations. Trying to deal with those. The first point of paragraph 23 was he said our construction reads the clauses in isolation from the rest of the contract. So paragraph 23. And our response to that is really to say, well, these are the very clauses that tell you in terms how the completion obligations are structured. They address directly the sequence of obligations as we say it. And there is nothing in the contract which displaces the clear meaning of those particular terms. And the judge really, we say, fell into just asserting that the contract as a whole had an overall meaning of simultaneous transfer or exchange, and didn't pay sufficient regard to the actual wording of the operative clauses we just looked at. Now, he referred to the so-called transfer terms, which is a defined expression. That you will see at page 137. And it's near the bottom. In fact, it's the last definition, transfer terms. You'll see that. In my submission, that doesn't really add to the crucial question. It just tells you what is being bought and sold. It just tells you what the shares are and what the consideration is, the option price. So that doesn't materially add to the debate. And at the end of clause 2.1, you'll see that there's reference to that defined term, transfer terms, at the end of 2.1 on page 138. But the concluding words of 2.1 are to purchase all the option shares on the transferred terms. So my submission, it just doesn't really add anything one way or the other. So the judge was wrong to say that supported his construction. it's all ultimately a question of what 3.2 and 3.3 mean. The judge's second point at judgment.
Did I detect that you said that when transfer terms says it means on the following terms, you argued that that meant not just A and B, but all the following terms of the agreement?
Well, it's clause 3.2 and 3.3 that are addressing directly what you actually have to do to complete, and that's my point really, that those are the specific clauses dealing with that question, and just the general reference to transfer terms at the start just doesn't really help you. The transfer terms, as I say, are just telling you what it is you're buying and selling. It's just not addressing the sequence of obligations. So it just doesn't add anything. That's really the submission on that point.
So you're not suggesting that on the following terms in the definition means any more than A and B. You are submitting, are you, that when you look at 2.1, the purchase required is on the transfer terms, and it's 2.1 to 3 that identify what is to happen.
Yes. I'm not making any particular point about the definition. I'm just saying it's.
I think your skeleton did say that on the following terms in the definition.
Yes, I think that
meant not just A and B, but the
yes,
whole of the terms in 2 and 3. Are you drawing back from that?
Yes, I think I am, to be fair, because it doesn't really matter, and it's 3.2 and 3.3 that are the operative provisions. Now, the judge's next point was the single transaction point of judgment, paragraph 25. So this is, well, completion is a single transaction. It's apparent from the contract that completion is a single transaction, and that supports, on the judge's view, Iconic's construction. Now, the clause that's relevant, or said to be relevant here, is 2.3. That's on page 138. And again, it's the same submission really in relation to 2.3. My submission just doesn't really add anything in relation to the crucial question. This is just telling you, clause 2.3, what they have to do to exercise the option. So it's addressing something different. That is quite literally the subject matter of that clause. It's telling you what they have to do to exercise the option. So it doesn't inform the crucial question of who has to do what at completion. The judge's third point was, and this is judgment paragraph 26, page 89. The judge's third point was, well, when the parties to this contract wanted to make something conditional, they said so. And he gave an example of that. But of course, our immediate answer to that is that that's what they did in 3.2 and 3.3 by the express use of the subject to language.
Well, I think the judge's point was when they wanted to make conditional, they said they used the word conditional.
Yes.
Whereas subject to is language which can quite properly be construed as provided that, or in return for.
Yes,
that might be a better way of putting it.
Yes, I'll go on to the clause he gave as an example, but we say there's no difference between conditional on and subject to. There's no difference in this context. They mean the same thing.
Well, I know you say that.
Yes.
But if it's right that subject to can, as a matter of language, simply mean in return for, is it wrong to place any reliance on the fact that where they've meant conditional, they've actually said conditional?
It's the fact that it's subject to Iconic complying with its obligations. It's not just the subject to, it's subject to Iconic complying with its obligations.
Right. If it had used the words in return for,
Yes.
would you still say that that was an if when and involved a temporal bifurcation?
Might be, I might do, but that's a very different use of language. I would accept that's a very different use of language. But as I say, the easiest way is just to say in terms there'll be an exchange, which they didn't do. They said subject to compliance. And my submission is there's no difference of substance between that and conditional. It is conditional language.
Actually, in many sales situations, whether it's delivering sale of a car, you deliver the car against the purchase price. You could quite easily say, on delivery of the car, you will pay the price. Now, is that conditional? It's only when you get the car you pay the price out. I think one would say not. One would say that you're saying on delivery of the car you'll pay means that the two things are mutual.
In my submission, it's the combination of 3.2 and 3.3 here. Not just each, it's a combination of step 1 being a mandatory, you shall do this, and step 2, as we say, being subject to complying with step 1. It's that combination of the two that wouldn't necessarily be the case in other contracts.
Well, it's commonplace though, isn't it? You have the subject matter of the sale, and then you have the payment of the price. And you don't expect someone will pay the price until the goods have been delivered to them. But equally you expect that they will pay on delivery.
Yes. Yeah.
Your argument here is, it seems to me, is putting a huge amount of weight on the alleged conditionality of words which seem to be no more than commonplace in a sale contract, which is that what is being sold is to be delivered at the time when the price is paid, and the price is only paid when the goods, or in this case shows of action, are delivered.
No, we're not disputing the general proposition about, obviously everyone recognises that under general sale of goods law there's a presumption of concurrent conditions and so on. We're just saying when you look at this particular language, and we absolutely are placing heavy reliance on the wording of the operative clause.
But you are saying that Section 28 of the Sale of Goods Act would effectively be displaced by a contrary agreement.
Yes.
If your contract for the sale of a car said, subject to delivery of the car, we will pay you £5,000.
Well, if it had, it's the two steps. It's you shall deliver. Step 1, you shall deliver the car on this day, full stop. And then second step, subject to you complying with that obligation to deliver the car on that day, the buyer shall pay the price. If it said that, we'd say that is clear. If it had those two steps. So it is more than just a seizing on subject to. It's the two steps.
The judge entitled to take into account the way that contracts of this kind are generally performed. In other words, you have something called a completion meeting. And in general, as Lord Justice Phillips said earlier, by some process of undertakings, documents will be released against money.
Yes, I mean, we've never disputed that background exists. And taking it into account would be wrong in itself. We're not saying you should just totally ignore that and it's impermissible to even have any regard. It's more that ultimately the question is, what have these parties agreed, and have they agreed to depart from that more typical regime in this particular contract? When, as I say, they could easily have used the terminology of exchange, but they didn't.
I mean, putting it more bluntly, if one's dealing with a purchase of something worth tens of millions of dollars at a completion meeting, the expectation would be that the procedure is going to be such that each party is satisfied that they're going to get what they bargained for in return, not that one should go first and be at risk of not getting the other.
Yes, that might be true as a general proposition.
Yeah,
but
that is the sort of real commercial background against which the document has to be construed. And you say that's
but
not what's been agreed here. Perhaps might be unusual, might be unwise,
yes,
but the language is sufficiently clear to achieve that.
exactly. That's why I mentioned at the start the asymmetry of the protections, that whether they're the greatest protections or not, the draftsman has written in a series of protections for them in relation to a payment default. So there's a structure in place that is rational on our construction, perfectly rational on our construction.
But a more rational construction
Well-
is that these are additional rights if the documents are tendered but the price isn't there, rather than catering for a position where there is a sequence but a failure simply to perform on the part of the purchaser.
Where we part company with that is we don't say it's more rational, we say it's more desirable for them. There's nothing irrational about our construction. It's just now, looking at it now, they would rather have what your lordship has described.
Well, I think when you come to the judge's fourth point, when he refers to completion, and there is a completion meeting at one of the company's offices, it is irrational, isn't it, that you might have events which actually do not amount to completion in your analysis?
No, it's just that completion is two stages. The fact that there's going to be a meeting is clear from the contract, and we don't dispute, or envisage that there will be a meeting. It's clear from the contract, and we don't dispute that. But we say that doesn't tell you what the answer is to the sequence of performance question. You can still have a meeting where there are two steps, the first being that they deliver the documents, and the second step being...
No, but you might have a situation where the documents are delivered and then you don't pay.
Yes, so
So
completion
you haven't got completion.
Yeah, the two steps of completion have not taken place.
What do you say is the purpose of completion being contemplated as taking place at a meeting?
I'm not sure we'd say anything other than that's what usually you would expect, some kind of completion meeting.
But on your analysis, you could, if the meeting's at 10 a.m. and they hand over all the documents, you would have till the end of the day to pay, wouldn't you?
Yes, unless it's implied that it's within a reasonable time or whatever. Yes.
Well, sure, it's implied that it's at the meeting.
Yes, that there are two steps that will take place at the meeting. You can still have sequential performance at a meeting, is my point, really. There's nothing about the mere fact that there's a meeting that...
Surely the fact that there's a meeting, that's precisely so that everything can be, so there can be that mutuality. If there's no obligation of mutuality, you don't need the meeting. They could deliver the documents to you, and you pay sometime later in the day. But the whole point about the meeting is everyone's together so that you can exchange. Otherwise, why have a meeting?
But why didn't they say that, is my question.
They did. They said there should be a meeting.
They said there should be a meeting, but not that there should be an exchange. They could have so easily said that, well, that's what it amounts to, really. Whereas instead they said this. And we say the mere fact there's a meeting, we can't get away from that, we don't dispute that, that's very clear in the contract. But you could have sequential performance at a meeting, is our point. So essentially,
Can you think of any rational explanation of why there would be sequential performance, given the background, which I think you accept, that in a typical regime there would be exchange? Can you think of any rational explanation of that, other than just the words that you rely on, subject to?
I mean, it protects my client's position, obviously. I mean, he only has to perform second when the documents have been delivered. So, obviously, two sides to the story.
But he is equally protected by mutual exchange. He only has to perform if and in exchange for the document. So he has that protection if it is the usual case of mutual exchange. What would be the rational basis for allowing him to get the documents in advance of and without paying?
Well,
I think that's my Lord's question.
yes, I understand the point, and in a sense, I would say, well, we don't need to. I mean, that's what it says. I'm afraid it does come down to that, my lord. And now it doesn't create something that is unworkable or illogical. It creates something that is undesirable, perhaps, for them. And that's what it says. That's what it comes down to, my lord.
I'm going to write down no rational reason put forward as to why Mr. Textor should have the advantage of receiving the documents in advance of payment. Is that fair?
Well, I'm not putting forward
or do
any
you wish to have another go at putting forward a rational reason?
I'm not putting forward any positive reason other than it's desirable from my client's point of view, and I understand he'd also get protection. But my submission is this is what the contract says.
The only protection he gets is the protection of getting the shares and himself defaulting. In other words, it's not protection that anyone could, in a rational world, ever have agreed to give. It's for protection of a defaulting party, because he gets the shares and doesn't pay.
Yeah. But these are reasons, my lord, I think ultimately why it's wise to agree an exchange. I don't argue with that proposition at all. It's wise to agree an exchange, but they didn't do so here.
Thank you.
The fourth point, the judge also referred to 3.4. This is the deferring completion clause on page
Sorry,
1.
just on the third point, just before you leave that, which is this point about completion. I think that's the third point, isn't it? Oh no, sorry, the fourth point is completion. I'm so sorry. So you carry on.
Yes, he also referred in that context to the deferring completion provision of 3.4. And this goes back to the two-stage completion we just discussed. Because we say, well, all that's saying is that the party not in default may defer completion to a date not more than 20 business days until after that date, and until after such date. So the provisions of this clause 3.4 shall apply to the completion so deferred. So that gives both parties, if they're not in breach, the ability to defer completion. But so we say the way that works is that if they fail to deliver documents, we can say, well, we'll defer completion and give them a chance. If they deliver the documents but Mr. Textor does not pay, they can say, we defer completion to give you a chance to pay, because the two steps would not have both completed. Now, maybe that clause is saying something that's unnecessary, because one party could always give the other party an indulgence and say, well, you haven't performed on time, but we're going to give you an extra 20 days or whatever. So
if you don't pay, there's no sense of Iconic deferring completion, because they have given you the documents. All that would then be deferred is not completion, but would be your pay.
I hesitate to use this, but it did occur. It's the completion of completion, because it's a two-stage process. Completion as a whole has not.
But that's meaningless.
but what does have meaning?
Once they've given you the documents and you.
But what does have meaning is that completion has two stages and is not finally done until the two stages are finished. So it's ultimately this clause 3.4 can't trump the operative provisions, because at most it's saying something that's unnecessary. The judge's fifth point was at paragraph 28 judgment, and this is the point about clause 3.5. Now, clause 3.5 is at page 139. And this is the point that this clause might look more relevant than it is in my submission, because in my submission, what clause 3.5 is doing is saying all of the shares have to go at the same time. You can't say, well, here are 50% of the shares now, and I'll give you the other 50% later. That's what clause 3.5 is doing. And when it uses the word simultaneously, it's referring to that. It's saying all the shares have to be transferred simultaneously, not in dribs and drabs, not in tranches. So it's making a completely different point that doesn't inform the analysis of the crucial point in my submission. Now, the sixth point is the clause 4.2 point, and this was foreshadowed in exchanges earlier on. This is the sales process point. So in a sense, I've already covered that, and we say, well, held, the terminology is held, and you would, for whatever a period, still hold the shares, even when the sales process has been activated, and the transfer of title would take place when the shareholders register is updated, as they say. That's in the model articles at core page 316, the point that you remain the holder until registration. I doubt if that point is controversial, but that's page 316. And perhaps more fundamentally, the second stage to my submission is the clause 4.2 is not rendered unworkable on our construction. It's not rendered unworkable, as the judge says, because, as I said earlier, they can potentially sell the whole of their combined shareholding with Mr. Textor, if that's what's necessary to raise the money they're owed. So that's the substance of the matter. They can sell as many shares as are required to raise the money they are owed. So the substance wouldn't be affected by our construction at all.
So I say that again. If there are no option shares held by Iconic at the relevant time, how does 4.2a empower a sale of them?
Well, 4.2b is the sale of the combined ordinary shares held by JT and Iconic. So they can potentially sell all of his shares, including his original shareholding, and if he's got their former option shares, that. So their rights extend to that, to selling potentially the whole of that combined stake.
What happens if they only want to sell the option shares?
Well, they still can. Even if he holds them, they can still say, well, those are the shares we want to sell. They've got total right in relation to all of it. It just goes into the pot.
They wouldn't be combined ordinary shares held by JT and Iconic, would they?
Yes, but if they become shares held by JT,
yes,
they can still sell them.
Well, they can't sell them under A.
No.
And suppose that they don't want to sell any of their other shares that they themselves are holding. How can they sell them under B?
Well, I would say it's not all or nothing. They can sell what the amount of shares held by Mr. Textor necessary to raise the money, which might be all of them, but it might not be.
But it wouldn't be a sale of combined shares, some of which were held by Mr. Textor and some of which were held by Iconic.
Well, they've got any other options reasonably proposed. And as a matter of substance, I would say that their rights extend to the whole pot of those shares, depending on the circumstances. So in substance, their position is the same. They can potentially sell that whole pot or such part of it as is necessary to raise the money. And
the difficulty is that the whole of this is apparently premised on the fact that if there is not any payment, there will be option shares still held by Iconic.
Yes.
Which, if you're right, there won't be.
Well, it's not quite as stark as that because there could be for a certain period.
Yeah. But no reason why there should be for any period, and certainly not the kind of period that would be needed for the marketing of the shares.
Yes, but I do say this clause is not rendered unworkable unworkable on our construction. On our construction, it still works perfectly well. As a matter of substance, it just contains this language of how shares
It works perfectly well if we can interpret C as meaning a sale of the option shares held by JT.
But it's a bit wider than that, because the concluding words of the introductory paragraph are, which shall include a full range of monetisation options, including but not limited to A, B and C. And it's clearly envisaged that they can potentially sell the whole of Mr. Textor's majority shareholder.
Right.
Well, can I just say something about commercial common sense and the Doherty case before coming on to round 2? Now, commercial common sense, I think you understand my submission on that is different from, is this a wise thing to have agreed? And we say we're not in the territory of irrational or illogical. And the judge in his judgment, and this is really paragraph 33, 34 and 5, referred to the very high level commercial context evidence about these agreements that had been adduced in the preliminary issues trial. And all that very high level evidence amounted to, in my submission, was that it was part of the background to these agreements that they should have an option to sell their shares if the De-SPAC transaction didn't happen. And everyone agreed at that level that that was part of the commercial context at that very high level. But my submission is looking at things in that way, or having regard to that, doesn't really tell you anything about the much more specific question of how it is this option was meant to work and who was meant to do what on completion in what order. That very high level evidence tells you nothing really about that much more mechanical, detailed question, which can only be answered by reference to the actual terms of the agreement. And we would say that this high level approach to the commercial purpose took place in the context of a very expedited trial. The proceedings only started, I think, in July. The injunction was in August. The trial was in September. And in circumstances where there's no positive pleading of any relevant factual matrix by Iconic, there was no disclosure in relation to any such factual matrix and so on. So all we had really was a bird's eye view of the purpose, which would have been apparent from the documents themselves, that they were intended to have an option if the De-SPAC didn't happen. So ultimately it all comes back to the language of particular clauses. The Doherty case, we say, first of all, that this is moot because at most it said, and this has always been the case relied upon by Iconic in the context of ground 1, the Doherty decision in the Court of Appeal. We say it's moot because at most it says you need clear words to establish sequential performance. And our answer to that is, well, this is clear. The words here are clear. But if it matters, we'd say that that case doesn't establish any general rule of law or principle of construction to that effect, and that all it does is construes the particular provision at issue in that case, and is therefore unlikely to be of any assistance, because ultimately one has to construe this contract and there's no special rule or presumption at play in ordinary contractual construction. So as I say, it's my learned friend's case that he's relying on, but that's what we say in response to it. So either it doesn't matter, or in any event it doesn't set out a general rule of law. We don't take issue with it in the slightest as being a perfectly correct construction of the clause in that particular case, which is very different. So well, that's ground 1. I'm going to move on to ground 2. And of course, the preliminary issue was a very straightforward issue, whether the claimant was ready and willing to perform its obligations under clause 3.2 of the put option agreement on the repayment date. That's issue 2, preliminary issues. And the repayment date is the specific date of 26th of July 2024. So it's, were they ready and willing to perform their obligations under clause 3.2 on 26th of July 2024. Now I'm going to approach ground 2 in 2 stages. In the first stage, I'm going to look at the reasons actually given by the judge for finding the answer was yes. In the second stage, I'm going to consider the various new arguments deployed in Iconic's appeal skeleton, which we would say are actually very different from the reasons given by the judge. However, so there's a unifying theme to all of that, those 2 stages, which is that the actual preliminary issue, we say, was a perfectly straightforward question of fact by reference to a date, a known and specific date in the past. Were they ready on that date or not? Ready and willing on that date or not? Absolutely straightforward question of fact. And their obligation under 3.2 was to deliver the documents. So very straightforwardly, the preliminary issue was asking, were they ready and willing to deliver those documents on that date? And we say, when you look at the facts that are not really disputed, the only answer is no. They didn't even have the documents. They didn't have the documents ready to be delivered as a matter of fact.
Is the question, were they ready in the sense that they had the ability and capacity to do so, had payment been indicated as being available on the day?
No, we say it's not. We say it's just an absolutely straightforward question of fact. And the unifying theme is both the judge and we say Iconic in its appeal skeleton are taking that straightforward question of fact and are trying to twist it into something else, which is more along the lines of what your lordship just said, a kind of hypothetical question. Could we have been ready in different circumstances? And that's a different question. Whereas the actual question posed, and I'll show you why it's important, how it came about to be posed in that way, was just absolutely straightforwardly, were you ready?
But does ready mean capable? Or does it mean, in other words, able? In other words, not unable?
Yes. It just means ready. Ready.
Well, suppose they'd had all these documents. Suppose they had, in fact,
Yeah.
executed all these documents,
Yes.
but they weren't at the registered office. They were with their solicitors. Would you say not ready because they'd have had to go and get them from the solicitors on the day?
Well, they had to be ready to deliver them.
Well, but are you saying in those circumstances they weren't in fact ready to complete as required because they didn't have them at the registered office?
No, I wouldn't say they needed to be physically there. They needed to have the documents ready.
But the contract requires them to deliver the documents at the registered office in default of...
Well,
So-
that's true. Yes, I see your point. Yes, but they need to be ready to do that, not to actually do it on this hypothesis.
Yes, but is it your case that therefore, if they had all these documents, but they hadn't taken them to the registered office, that would be fatal?
Well, they'd be ready to do so.
In those circumstances, they would be ready to do
Yes,
so.
yes.
So it's not a question of whether they were in fact ready to comply. It's whether they would have been able to comply had the completion meeting taken place.
We're going to look at a case in a moment.
All right.
Actually, one of the cases they've cited says that in this formulation of ready and willing, it implicitly must include able. So we certainly rely on that. So they must be ready, willing, and able to deliver the documents on the day.
Yes, but I'm just trying to press you on whether able means they actually had them, or they were able to produce them had the completion meeting taken place, although it didn't take place because your client had said he wasn't going to pay.
I suppose there might be a situation where they have the documents, but they're physically on the other side of the world, and there's no possibility of delivering them at a completion meeting.
Well, but conversely, they may be in a position where, had the completion meeting taken place, they could have produced them on a word processor within 30 seconds.
Yes, but we say there's
And that you say that's not good enough.
it's not good enough, no. And it isn't this case. They couldn't have done that in 30 seconds. But anyway,
Let's just examine the principle.
yes.
Let's say they hadn't prepared a share transfer form, but if there'd been a completion meeting, there's no doubt they would have been able to knock
Yes.
one up in 30 seconds.
Yes.
You say that won't do.
Well, I did accept at the trial, and this is referred to in the judgment. That, I mean, imagine that was the only point.
Yes.
Imagine that was the only point, that they hadn't filled out the form, which could be done unilaterally by them
Yes.
in 30 seconds on that document.
Yes.
Then it seems very unlikely we'd be here. So
That's not an answer to the
but-
question. Do you accept that
strictly-
that would preclude them being able to say we were ready,
well, strictly
but they hadn't done it?
strictly logically, yes, but it becomes, I can see why that becomes ridiculous if that is the only point. But obviously in this particular
Exactly so,
case-
and that does suggest, doesn't it, that at the very least, readiness comprehends being in a position to produce at the completion meeting, had it taken place, not that they had in fact executed the documents.
Yeah, I mean, if you've got a bit of paper that just needs to be signed, and you can't.
But if you
say
haven't
you're
got a
ready.
piece of paper, but if there'd been a completion meeting, you could have knocked it up
No, but-
in the course of the meeting. Is that any different?
Yeah, but what you can't do, we say, is twist it into a completely hypothetical scenario where you say, well, if Mr. Textor had said, I want to go ahead, we could have acted completely differently and got ourselves ready by the date, because that's what they're trying to do, and that is just a completely different inquiry.
Does it, I wonder if does it really come down to this, that actually the test is, are you willing and are you able? If you are willing to do it and you are able to do it, then you are ready.
Well, the word ready is there for a reason. It does suggest you're actually ready to go.
But you accept you haven't got to have the documents at the premises, and you don't. I don't think you seriously suggest you need necessarily have executed the transfer.
No.
But those are matters which you are able to do and you're willing to do them. And I think you accept that for that you could execute the document and take it to the office means you're ready. So I wonder if it means anything. And the key thing here is the share certificate, isn't it?
And the power of attorney and yeah.
Well, maybe, but the share certificate is the big question, because you say they were not even able
Yes.
to produce that.
Yes.
And so therefore they cannot be ready.
Yes. And yes. I mean, let me start by, can I just look at paragraphs 38 and 43 of the judgment, because they may help on the framework for all of this. So that's tab 6, paragraphs 38 and 43. So obviously this part of the case assumes we're wrong on the construction. The judge at 38, second sentence, in those circumstances, if Iconic is to succeed in its claim for specific performance against JT, this clause 3.3 obligations, then Iconic, or obligation, then Iconic must show that it has always been ready and willing to perform its obligations. And then at paragraph 43, 2 pages on, as is common ground, if Iconic is to succeed, it must establish that both JT was not willing and able to perform its obligations, and that Iconic was willing and able to perform its obligations on 26th of. So that's the framework. Now,
Well, that's using ready and willing and able as interchangeable.
yes, as I say, the case that I'll come to in a minute really says it's ready, willing, and able. The analytically correct formulation is ready, willing, and able. And we say that's right.
That's not the formulation of the preliminary issue.
No, but actually what the case is saying is able is implicit in ready and willing. So it is implicit within it. Otherwise, it could just be meaningless. You could be saying, "Oh, well, I want to go ahead. I'm we want to go ahead, but not actually be able to, and that plainly wouldn't be good enough.
You can't be ready if you don't have the ability.
Yes.
But conversely, when one's looking at having the ability, you don't actually have to have done everything in order to be ready. And the question, which may be an important question of law, is what is the period within which you would have been able to make yourself ready? And one sensible commercial answer, it may not be the right answer, is within the period of notice that you would have had the completion meeting been going to take place. So in the real world, the completion meeting is not going to take place in a vacuum. There is going to be some correspondence before it. There may have been some talk about whether you should have an earlier date, convenient for everybody's timetable, getting the solicitors there, whatever it may be. Radio silence about it is not actually realistic, other than in circumstances in which one party has said he's not going to perform.
Yeah.
And therefore, a sensible commercial approach might be that if one's looking at readiness, it is, in the circumstances of this case, say 48, 36, 72 hours, which would have been the relevant period of notice that they would have had to actually get the documents together. Now, I know you say that they wouldn't have been able to do that in relation to some of the documents,
Yes.
but in terms of whether the documents were in fact there, or the period within which they would reasonably have been able to prepare them in order to say they're ready, would you dissent from that approach?
I think I understand what your lordship is saying, but that would be a very different preliminary issue. It's not the preliminary issue actually posed, and I've shown you those paragraphs to show that.
I'm not sure it is. If the concept of readiness at a particular date does not require all the documents actually to have been there on the date or to have been executed on the date, but is a question of whether there was an ability to do so.
Yeah.
It may be that the ability is not confined to an ability to produce it on the particular day, but an ability to produce it by the particular day within the period of notice that one could reasonably commercially expect it to have been available, that there was going to be a completion meeting on that day.
Yes, but
I think that's the proposition I'm putting to you.
yes, I understand, but they accepted they accepted that they had to show they actually were ready on that day. That's how we characterise
But what I'm putting to you is that formulation is consistent with ready on that day, in the sense of they had the capacity to have the documents available on that day, had they had noticed that completion was going to go ahead of the period which is realistic, if it were going to go ahead. Is that you balk at that? You say it's only what they would have been able to produce on the day?
Yes, because it's the Simona point that there's no third way. When faced with a repudiatory breach, they've got a binary choice between two options. They can either accept that as bringing the contract to the end, to an end in claim damages, or they can continue with the contract, in which case they're fully liable to perform all their obligations and to get ready to perform on the day.
Well, they have to be ready and willing to do so. They don't have to actually perform.
No, but they have to be ready on the day. And there's no third way. This is the Simona and the recent Hitex case in the Court of Appeal. You can't say, well, because you've repudiated, it's not necessary for me to perform and I could just go along with the contract. You have to choose one option or the other. You can't, there's no middle course.
Is that case about this question, which is ready, willing and able, which is what I think the questions are about at the moment?
Well,
because here the party is saying, the innocent party is saying, look, I want to go ahead with the contract.
Yes.
And this is in the this concept is being used in the context of an application for specific performance of the contract. And the question then arises, well, what does the innocent party have to show in order to get specific performance. And one of the things is that he is ready, willing and able. And these questions are concerned with that question, is that the innocent party isn't saying he's discharged from his obligations. He accepts that he's got the obligations to deliver all the documents and so forth. But the question is, what's meant by ready, willing and able in this context?
In my submission, it does inform it, because basically the situation they were in is they didn't accept any repudiatory breach, and therefore they remained fully liable to get ready, to actually get ready to perform.
But when the other party, when the party in breach has said, I'm not going to turn up to a completion meeting, which is essentially what's happened here, what's the point of lining up? I mean, are they supposed to sit there in a solicitor's offices on their own and go through a sort of charade of handing over documents?
No, it's that they can't do the middle way. Essentially what they have done is the impermissible middle way in the Simona. They've said, well, because you've said you're not going to perform, we're not going to get ready ourselves.
But they can't complete.
But they can get ready to do it, my lord. That's our. They can gather all the documents necessary, the share certificate. They can produce a power of attorney. They can get the package of documents ready to be delivered. There was absolutely nothing stopping them.
The logic of your argument is they do have actually to go to the registered office. Otherwise, they're not ready to complete.
Will be able to get there.
If what?
On your lordship's logic, that if
No,
you
but get ready, be able to get there. If what?
well, on the day.
Well, your
Because
point,
he's-
if on the morning you had communicated with them to say we have now managed to
Yes.
obtain finance from some lenders.
Yes.
We now have the funds available, and we would like to be pleased be ready to complete at 4 p.m. today at the company's offices, and you were entitled to do that because they hadn't accepted
Yes.
the repudiation, and that was within the reasonable range of possibilities, and they had to be ready, willing and able on the 26th of July to be at the offices at 4 o'clock to complete.
Yes.
Is what you say.
Yes. And that's the logical consequence of the Simona, that there is no middle way. You jump one way or the other, and if you don't accept, you have to get fully ready in order to claim this remedy as they accepted.
And if Mr. Textor had said so at 5 to 5 in the evening, hello, I'm at the registered office. I'm ready to complete. They would have to be ready and have all the documents there. And if they didn't get there in time, tough luck.
I can't remember whether the contract says anything about the hours, but
Let's say it's 5 to midnight. It doesn't matter whatever the deadline is.
yeah.
Is that realistic?
They couldn't exclude the possibility that he would, as the Lordship said, would be ready to perform, actually, despite what had happened. He said, well, actually, I've got money now, actually, I've financed it in place. That was very much a possibility. And all they have to do to protect themselves is get ready.
I think on your case, in order to protect themselves, they've got to be ready with all the executed documents and sitting in the office in case he turns up at 5 to midnight or 5 to 5 or whatever the deadline is. Because they can't. He's not obliged to give any prior notice.
Yeah.
He can simply turn up and say, "Now I'm ready. Here's my banker's draft," or "I've got my bankers on the phone ready to." Assuming it's mutual exchange, and so they're actually obliged to sit there with all the executed documents and wait.
Will be able to get there if he contacts them and says, "I'm ready to go ahead." But I mean,
No, but I think on your case, he doesn't have to contact them to say he's ready to go ahead. All he has to do is turn up. Why does he have to contact them on your case?
hang on. Just need to check the contractual wording in 3.1. Well, if they were able to get there with the documents, they'd be ready, willing, and able on the day.
Yes, but I think your case is because it's an unaccepted repudiation. All he need do is turn up on the day
Yes, and this is the world
without any notice, and in order to show that they were ready, willing, and able, if he didn't turn up, they've got to be there with all the documents all day in case he does turn up, because otherwise they can't show that they were ready if he'd performed his part of the bargain in a way he was entitled to.
No, I'm not submitting they need to physically turn up. They need to be ready to deliver the documents at that place on that day. But of course, this is a very extreme example. On the actual facts, they just didn't have the documents.
No, on the actual facts, everybody knew he wasn't going to turn up because he'd said he wasn't going to. But I think the logic of your case is that they've got to be there. Otherwise, they can't say, we were ready if he'd turned up at 5 to midnight.
No,
Or we were ready if he'd turned up at 5 to 5.
I would say the ultimate extent of my case is they've got to be ready, willing and able to get there on the day. Not to actually be there, I mean, insofar as that matters.
Well, but is that, I wonder if any of this really arises because questions about whether the fact that you are in anticipatory breach, the effect that may have on the obligation to complete is a different matter.
Yeah.
The only issue which was being decided by the judge was, were they ready, willing and brackets able to complete on that day?
Yes.
That was the issue.
Yes, and that's my core submission on this ground, that was the issue.
It may be open to Iconic to argue as a different issue that they weren't obliged to be ready, willing and able.
Yes, that would be a totally different argument, because as I've shown you, the whole trial was conducted on the basis that they had to show that, and if they didn't, it was a knockout blow for us.
But I think our discussion about the time deadline it means that you're accepting that all they had to show is that they were ready, willing, and able to complete if you'd given notice at the beginning of the day that you were going to turn up. I don't understand the logic of that, but that is you at least realise that commercial reality has to go that far. But the if question, why should it be confined to giving notice at the beginning of the day rather than what would realistically be expected? If it's a matter of contractual entitlement, so that no notice needed to be given, and he could turn up at 5 to midnight or 5 to 5, whatever the appropriate deadline is, then your case ought to be actually ready and able whenever he turned up. If, on the other hand, your case is subject to a realistic notice, why do we treat the realistic notice as being given at the beginning of the day rather than realistically within a matter of days, which is what the parties would commercially have expected had he intended to complete? I think that's the tension I'm having with your logic. It may not matter on the facts of this case whether they had a day to do it or they had several days to do it, but it frames the question as what's meant by able.
Can I deal with what the judge said and see if we can tease it out that way? Because the judge, none of this was part of the judge's reasoning.
No.
The judge's reasoning was, well, there would have been a solution worked out.
Yes.
And therefore, they were ready and willing on that day.
And you say that's the wrong question.
We say that's the
I
wrong
entirely
question.
understand that.
Yes.
But I'm not sure how looking at what the judge said is going to help with my
No.
inquiry as to how you say the right question is framed.
But clearly, I've got to cover that in my time. Otherwise, we say the judge got the wrong approach, and he said, well, there could have been a solution where Mr. Textor would have waived certain requirements, which was completely hypothetical.
Yeah, I understand all that argument as to the way the judge went about it.
Yes, and I just say one further thing about it before moving on is that none of that was explored with Mr. Textor in the evidence. So it wasn't suggested to him, well, you would have just agreed this. There was no evidence about that. It was the judge's own analysis of what would have happened or what could have happened. And he dealt with power of attorney very briefly, as you will have seen right at the end of the judgment, 67, and just said, well, that would have been agreed, but without really focusing on what we say is the right question. Now, that's that's the judge's reasoning, and I can obviously you've got my points on that. Now, in terms of the new points in the skeleton, the appeal skeleton, we would say that what's one of the things that's striking is that little attempt has been made by the respondent to actually defend the judge's reasoning on ground 2. It's alluded to really at paragraph 68 of their skeleton, page 63 of the core Bible. So paragraph 68 of their appeal skeleton. And they refer to the judges pointed out the undertakings, etc., and then they say about 2/3 of the way down, however, it is unnecessary to go that far, i.e. as far as the judge went. And they say the key point is that a share certificate could have been issued by the parties themselves. So that is a different point, and of course I think you have the point that that was not raised in any way at the trial, the ability of the directors to issue a share certificate, including the Iconic directors to issue one to themselves. Now, and we do say basically what Iconic is doing is committing the same error as the judge in a different way, by changing the question, the issue, into a hypothetical. And essentially what they're trying to do now is to change it into could they have been ready to perform on the 26th of July if Mr. Textor had indicated he'd been ready, willing and able to perform.
But I thought you'd conceded that at least so far as within the day is concerned, that is the right test.
Well, in relation to the stock transfer, exactly, that point of principle, that if it's just literally a question of filling in a form that you can do unilaterally.
Well, forgive me, I thought we'd got to you accepting, because of the commercial reality of it, that the question is whether within the day they could have produced the documents if they'd had notice first thing in the morning.
Yes, but they're trying to say something different from that, which is, could they, in a counterfactual, have got ready? I'm not sure their case is confined to in the day. It might be, I don't know.
Well, I'm just looking at share certificate could have been issued by the parties themselves within a few minutes. Then they may be right, they may be wrong about that, but that's if they're right about that. Why doesn't that? Why doesn't that fall into the same category? Signing a share transfer.
They've certainly said in a number of occasions it's a counterfactual question. What really they say now in their appeal skeleton, when you analyse it, it's a counterfactual question, not a factual question.
Yes.
So they've certainly, in my submission, engaged on that twisting of the actual issue.
No, but I'm sorry, I know I'm taking a long time on this, and you've got other points to make. But on your case, it's a counterfactual question. It's not were they at the offices, but could they have got to the offices?
Yes, in a
not
very
did they have the signed transfer form, but within the day, could they have produced and signed it?
Yes.
If the question is, could they within the day have procured a share certificate as required, then that's no different. They're all counterfactual questions in the sense that it's what would have happened on the day.
Yes, but I don't understand them to be confining themselves to a case that all that matters is could they have done it on the day. I think they have made points like that, but I don't think they're limiting themselves to that.
Right. So that is the point that's made in paragraph 68 anyway.
Yeah,
is it? Forgive me. I just query. I wonder if you are proposing a counterfactual, you're saying you have to look at what was the actual position on the day, not counterfactually. What was the position on the day? And then the question is, did that mean they were ready, willing, and able?
Yes.
And you're accepting, I think, that in order to have been ready, willing, and able, they must have been in a position to have attended and completed as a meeting at some point on that day.
Yes.
Now that's not counterfactual. That is what was the actual fact, and the question then is what do they have to show in relation to the actual position to show they were in fact ready and able?
Yes.
Let's assume that they're willing.
Yes.
But it's counterfactual in the sense that could they have done it if and it's the if
In a
which
very limited-
introduces a counterfactual. And I think you're accepting the if at least goes so far as being told at the beginning of the day that completion was going to take place that day.
Because if it was only the stock transfer form, they could have filled it in. They wouldn't actually have had to fill it in. So in that sense, but ultimately the question is, as your lordship has posed, it's what was the position on the day? And I've got to cover the share certificate because this is obviously important. There was no argument or evidence about the ability of Nasta or Deanon to issue one unilaterally at the trial, and no suggestion that they thought or believed they could do so or would have done so.
Forgive me, the starting point on this, what was the evidence or position of the parties at the trial on whether a share certificate had been issued and lost?
It was unclear because there wasn't this focus that there is now. It's the new argument now puts that into sharp relief because they say, well, we could have issued one ourselves. And then it matters what the history is, what the exact history is, because you can't issue one yourself if you've lost it. But at the trial, there was no such argument. So it just wasn't investigated in this way.
But we have the documents. We know, for example, that subsequently Iconic issued is it an indemnity in relation to a lost certificate?
Yes, I was just going to come on to that.
It seems to suggest at that point they seem to be asserting and or accepting
Yes.
that the certificate that they had a certificate and had lost it.
Yes. Let me show you that because I was just about to come on to that. It's tab 24 and tab 25 of the supplemental bundle. So tab 24 is the covering letter in June 2025, so about 11 months after the completion date. And this is where, for the first time, they produce draft versions of the documents referred to in clause 3.2. And you'll see they actually, in the 4th paragraph down, at the end of the 4th paragraph down, they invite comments on those documents, including the power of attorney. Then the documents themselves are behind the next tab, under a covering email from their solicitors. I've got this, an unsigned stock transfer form on 93, the power of attorney, page 95, and then the document your lordship just referred to, page 99. So this is 11 months later, and they produce this document entitled Indemnity for Lost Share Certificates. So it actually goes further than that, because if you look at the first bullet point, it says we confirm the original certificate of the title relating to the shares, which in the capital of the company the shares has been lost. And they offer an undertaking, and you see in the middle it says in consideration of you doing so, i.e. registering the transfer, they make 2 bullet points. And the second bullet point is we undertake to return the original certificate to the company for cancellation if it is found.
Well, I think the whole of this is quite important, isn't it?
Yeah.
Because the second bullet point is a confirmation that it hasn't been transferred, charged, lent or deposited.
Yes.
Which goes to the heart of why you need the share certificate.
Yes.
Or otherwise the indemnity, because the share certificate may have been pledged to a third party.
Yes. So that's.
This is for what they're asking for here is because it's addressed to the company. They're asking the company then to register the shares in the name of your client. So they're not asking for a substitute share certificate.
No.
They're asking for a new share certificate to be put into the name of the purchaser.
Yes. But they're clearly representing the loss of,
Yeah, I see that.
and then the other document is
But
tab.
they have done that on the day. Supposing they had served that document on the day,
It's not good enough, my lord, we'd say, because it's not the share certificate. It simply isn't. It's just non-compliant. And it involves, the indemnity has to be accepted by the company. So it's a different relationship, and it's simply not what the contract requires. If you don't produce the share certificate, you haven't.
no, this is a deed, which is a unilateral deed.
Yeah.
Which is in fairly standard form
Yes.
to deal with this sort of situation. So
Yeah.
where someone is selling a share and then they can't put their hands on the certificate, this is the standard way of doing it.
But it's non-compliant with 3.2, and obviously what you'd do is try and sort it out before the completion date. You would say, well, look, you know, this is what's happened. Can we sort out some consensual solution? That might be what you do in practice. But in terms of contractual analysis, you've either got the certificate or you haven't, and they didn't have it. And you can actually see at tab 34 the other document that's relevant to this. Because on the 17th of September 2025, this is referred to in our skeleton, this is shortly before the trial, this is when they actually wrote to the company asking for a certificate, a share certificate. So long after more than a year after the completion date, they wrote to the company asking for one. And you see that on the second page at point number 3. Now, I'm sorry, this isn't, I fully accept I'm not going to be able to give a clear, factual explanation of what did or didn't happen. We have, because it hasn't been investigated, the judge said it's common ground that they didn't have and possibly never had a certificate. That was the only finding he made about this, possibly never had a certificate. As you've seen in our reply skeleton, one of the things they said in their appeal skeleton is you should infer, the Court of Appeal should infer and act on the basis that no certificates were ever issued. So that's an invitation to you to proceed on that factual basis. And that would obviously help them, because they could say, well, if we're in a scenario where none were ever issued, we could have issued one to ourselves. And it was in response to that that we were able to locate a PDF copy of a share certificate in their name, which is attached to the supplemental skeleton. But we simply haven't conducted a new disclosure and fact-finding exercise to piece together exactly what happened at what time, but we have found a PDF copy of a share certificate in their name. The best evidence in my submission is their indemnity letter, because that's a carefully prepared legal document that expressly and explicitly represents that it had been lost by them. But there we are, it's a very unsatisfactory position. And obviously, had they run this argument at trial, it would have mattered a lot more what the precise story was, and it could have been investigated, but they didn't find it. But there's no basis to proceed on the basis set out in their skeleton, which is you should infer that no certificates were ever issued. We would submit you shouldn't do that.
Can I say we agree with that?
Yes. So you can't, in my submission, it follows from that you can't assume that they could have just made one themselves on the completion date, as they say in their skeleton. Because if you're in a replacement of a lost certificate scenario, you can't do that. That's core page 315. Switch on. you've got a certificate and you've lost it, you can ask for a new one, but the directors, plural, can impose conditions on that, including giving an indemnity or whatever they think is appropriate. So the board, or quorum of the board, can say, well, we're going to put conditions on giving you replacement share certificates. We might create a situation where there are two, because you say you've lost one, if we give you another one, we might create a situation where there are two in existence. That's core page 315. These are the model articles. So they refer to Article 24, the model articles, possibly also 25, but it's 25 that matters for this point.
Sorry, the model articles are incorporated.
Yes. So it's 25 that is a replacement certificate. So that's the situation they said they were in when they said they'd lost it. And you can get one, but then 25(2)(c), you must comply with such conditions as to evidence indemnity and the payment of a reasonable fee as the directors decide. So you can't, it must be right in my submission, you can't just circumvent that by just issuing one yourself with no conditions. A quorum of the board has to consider that issue. So we would say this appeal couldn't be decided on the basis of their new argument that they could have just done that themselves. They could have just issued a new one themselves. Just so you get back to really a simple question of fact, they didn't have one, and they hadn't asked for one on the completion date. And it's not particularly clear, but their own document of 2025 expressly represents that they lost it.
Well, it goes a bit further than that, doesn't it? Because the document at 99, the unexecuted deed, awarded executed, represent that it had been lost.
Yes.
But the covering letter at 89 represents to your client that the enclosed drafts are required by 3.2a.
We therefore enclose drafts of the documents required, yeah.
So they seem to be saying that an indemnity would be required.
Yes.
An indemnity saying that they had lost the certificate would be required.
Yes, and that's wrong.
That is, well, that seems to be, but whether that's the right document or not, that does seem to be a representation to you.
Yes.
That they have lost the certificate.
Yes. Yes. And we say, well, that wouldn't have been contractual performance. Exactly. Yeah. And it's important for the next point that they invite comments. So one of the other documents attached was the draft power of attorney that they had prepared. That's also attached to the documents we looked to earlier, and they invite comments. And that's one of our main submissions on the power of attorney, which I'm going to come on to now. In their skeleton, they try and downplay the power of attorney, and they describe it as a conveyancing triviality, a boilerplate with no practical utility. Those are the phrases, two of the phrases used in their skeleton. But at the end of the day, it was a required document under 3.2. That's very clear. And it's one of those clauses that says in a form acceptable to JT. The power of attorney has to be in a form
reasonably.
Reasonably acceptable. Hang on a minute. It's at page. Sorry, that was just a slip. So it's page 139 of the core.
Yeah.
So it's one of those quite common types of clauses, reasonably acceptable, where how is it going to work other than they put forward a draft and he has a look at it, takes some legal advice on it, which you would expect him to do, and says, well, I've got these comments, or I agree it. So one would think that that would happen in advance of completion.
Well, only if he gives notice in advance that he's going to complete. On the if question that we're looking at, it's if he turns up on the morning or gives notice in the morning. And the question is then, would a form that was reasonably acceptable to him have been capable of being produced within the day? Is that the right question?
Well, I mean, the facts are they didn't do anything. Those are the facts. They didn't prepare one. They didn't proffer one for agreement. So they didn't have a draft power of attorney in existence.
Didn't have a share transfer form
No.
either. But I think
they-
we're agreed. We're looking at the ability to do so if something had happened, and I think the if is on your case. He turned up or given notice he was going to turn up at the beginning of that day.
But as we said in our scope, the way we would look at that clause is it's plain that they have to give reasonably in advance of completion a draft for him to have a look at and take legal advice on. We would say it's implicit in that they have to produce it before completion.
When do you say it's implicit?
Within a reasonable time before, because
Which is
otherwise,
what?
how can he, whatever it would be? I mean, a few days or whatever. But he has to have a fair chance to have a look at it and provide comments and take legal advice. That's what the scheme there is requiring. That he's got to have a chance, and then if his points are unreasonable, they can tender what they say or deliver what they say is a reasonable power of attorney, and that can all be determined later whether they're right or not.
So suppose they can show that they would have produced something on the day if they'd been told, and that it would have been in this form that they produced later, and that the court can say that it would have been unreasonable not to accept it in those terms. You say that won't do?
Well, my first answer to that is they didn't do any of that. There's no evidence about any of that. They didn't say, well, this is what we would have produced, and they didn't cross-examine Mr. Textor saying, well, look at this thing we would have produced. You would have accepted that as a reasonable power of attorney. None of that happened at the trial. So that they didn't establish that. So they just never did anything in advance of the completion date. They didn't even create internally. There was no evidence they'd created internally any such document.
Do you advance any case that what was produced in the wording we've seen, that one you just showed us, do you advance any case that would not have been reasonable?
So we didn't go into that, and we haven't gone into that. What they did produce was not a one-pager. It's about 3 or 4 pages long and has various undertakings. But I can't pretend that we've ever, in this case, gone into the defectiveness or otherwise, or what would be reasonable criticism. We haven't gone into that. That wasn't an issue in the trial. In my submission, it didn't need to be, because ultimately the facts are actually very clear. They haven't done anything. And we don't accept that this is so trivial that we could be expected to agree it in 5 minutes. We don't accept that, given the value and significance of what's at stake here. Even this power of attorney would need to be looked at properly, and we need to have lawyers looked at it. We don't accept that they could just shove it under our noses and say, you've got 30 seconds to disagree with this.
But does it follow that on your case you could prevent completion?
No.
By turning up on the day, you don't have to give any notice, and then saying, I don't have sufficient time
Right.
to consider any document, even if it's produced and tendered, and therefore you're not in a position to provide a power of attorney which is reasonably acceptable, because I haven't had time for my lawyers to look at it.
If we say it's implicit, we be given a reasonable chance to have a look
And you say that's before the day.
before completion.
But on the other hand, you say they were obliged to be ready
Yes.
on the day itself.
Yes, because they can prepare one, give it to us, and we could make objections, and they can disagree with the objections and say our power of attorney is reasonable, and we're going ahead with our power of attorney because it is reasonable.
Yeah, so it is your case. I mean, I'm not saying it's wrong,
No,
but it is your case that what they were obliged to do was to take steps before the day, and actually they would have had to have sent you one.
Yes.
They can't say they were ready on the day to do it, because that wouldn't have been reasonable.
If there was
They had actually to prepare one and send it to you.
Yes. And if there was a dispute, that would have to be resolved later. We'd say, well, that wasn't a valid closing because you tried to impose a completely unreasonable power of attorney on us, and we don't accept that was valid. And then later on, a court would come to resolve that.
We have to on this issue. I think. Do you say this, that we have to approach this issue as though ignoring the fact that your client had said that they didn't have the funds, and ignoring the fact that there wasn't a proposed completion meeting on the day? The way we have to approach it is we have to look at it to say everyone was gung-ho to do this completion, but that on the day your client said to the other side, you're not ready to complete.
You don't have to add that last state. It's just simply, were they ready to actually do it on the day?
Okay, well, we're testing whether they were ready to complete, not on the hypothesis that your clients were in anticipatory breach on it, and that nobody was expecting that there would be a completion meeting, but on the hypothesis that everybody was fully expecting there would be a completion meeting.
Yes, because
were they ready, willing?
Yes, because of the Simona point, they had to get ready. They were fully bound by the contract.
I think everything is coloured to some extent, obviously in the analysis, but perhaps you would say that's the wrong colour.
Yes, because they're trying to do the impermissible middle way. We're saying we didn't have to get ready because you repudiated.
And on your case, they are conceptually entitled to say we're ready if we could have produced it on the day, but they are not conceptually able to say we would have been ready in relation to the power of attorney, because that is not something which could have been produced on the day without being provided in advance. Is that is that your case?
Yes, that is. That's right. Now, I'm going to, if given the time, I've obviously covered the new authority in quite a lot of detail in the reply skeleton. And the only one we're positively missing and averring is the Phillips case that says ready and willing includes implicitly able. That's a proposition we agree with, we positively agree with. But the other cases, we say they're all about something different. And I've got to get on to Premier League approval, so hopefully I can deal with this relatively briefly. And essentially the reasons are as set out with the in the reply skeleton. The case is in a number of categories. The Phillips case we agree with. You've then got Court and Ambergate, which is dealing with something very different, which is what happens when the seller actually accepts the repudiatory breach and says, I am bringing the contract to an end, but avers, well, I would have been ready and willing to perform the rest of the contract in the future, but now I'm claiming, it doesn't matter now, because I'm claiming damages. So that's a fundamentally different situation, we say. We've covered that in the reply skeleton, and we've given the references to Benjamin, and quoted them in the reply skeleton, that deal with that very different situation where you have an accepted repudiatory breach. And obviously the courts are, the courts are lenient on the innocent party in that situation, whose obligations to perform lay in the future. And he's just saying, well, I'm bringing the contract to an end, and I would have performed it had it continued. So quite a relaxed test or approach is applied to that averment in that situation, in that very different situation. But it's not this situation, as we've already explored. The next category is the notice to complete cases, and that's under the Law Society standard terms. That will be very familiar to the court. And of course, what you've got there is an express contractual regime. We put it in the supplemental authorities. It's the perfectly standard terms used in house sales. It's an express contractual regime with a completion date where time is not of the essence. And then you can serve a notice to complete making time of the essence by requiring the other party to complete in 10 working days. And what the contractual term actually says is you need to be ready, willing and able to complete when you serve the notice to complete. And what the courts have said is that doesn't mean when you serve the notice you need to be ready, willing and able to complete that second. So if you're the purchaser, you don't have to have the whole money just ready to go. It means you're ready, willing and able to complete within the 10 working days referred to in the notice. So it's forward-looking. When you serve the notice, you have to show that you're ready, willing and able to complete within the 10 working days going forward from the notice. So those cases are dealing with something quite different, a different contractual regime. Then you have, again, this is all in the reply skeleton, Peggy and Lamb and Grant and Sigmund, which are about share sales. Peggy and Lamb is a Hong Kong case, but features Lord Millett sitting as a judge of the Hong Kong Court of Final Appeal. And as we pointed out in the reply skeleton, what he was dealing with was a contract with no fixed completion date, where the claimant purchaser went to court and was essentially asking the court to fix a future completion date. And it's really the same point. She didn't have all the money right there at that moment ready to go, but she was saying, well, look, here's the evidence that shows I can get the money together to complete the purchase in the future, and that means I'll be ready, willing and able on the date in the future where we have to complete. So the whole analysis is about that. It's got that forward-looking element. Contrast our case, where there's no forward-looking element. There's a question of readiness and willingness on an identified date in the past. It's a different question. And then Grant and Sigmund, the point there really is an argument about repudiatory breach. It's a summary judgment about repudiatory breach. And the share certificates come into it in that way because the buyer was saying, well, you're in repudiatory breach for not delivering the certificates on the completion date. Therefore, I can terminate the contract. And the two reasons given by the judge for rejecting the repudiatory breach case are, one, the other side had actually asked for the certificates prior to completion and you hadn't cooperated. So you can't rely on your own lack of cooperation. And that obviously doesn't apply here because they've never asked it. Iconic had never asked for any cooperation prior to completion in relation to share certificates. They've never asked anything. And the second reason is, even if not delivering the certificates on the completion date was a breach, it wasn't a repudiatory breach because it's not so fundamental as to go to the root of the contract and so on. So that's not the argument we're having here. We're not having a repudiatory breach argument. We're having a specific performance argument where you've got to deliver a defined list, be ready and willing to deliver a defined list of documents. And it doesn't really matter in that context to say, well, this document wasn't very important. If it's one of the contractually required documents, you've got to be ready and willing to deliver it. There's no repudiatory breach type analysis in our case, we'd say.
If you were right, your client would be able to say at the end of the repayment date, you haven't performed because you haven't delivered a certificate. That's a repudiatory breach.
Yeah.
Is it actually really any different?
Well, it is because they've always accepted to get this remedy, they have to show they were ready and willing on the day to comply with their obligations as set out. So you can't pick and choose and say, well, I was ready to comply with most of them, and the ones I wasn't ready to comply with are not very important. That doesn't work on their case, in my submission.
Does it? I mean, I don't know the answer to this question, so it's a genuinely open question. But in the cases on specific performance, does the person, the innocent party or the party seeking specific performance, have to show that they could comply with every last obligation, however unimportant, or is there any test of substantiality or materiality or anything of that kind?
I'm not aware that point has been raised and looked at in this case. I mean, certainly the judge was proceeding on the basis in those paragraphs we've looked at. They just had to be ready to perform their obligations. I'll be corrected if I'm wrong. I don't think there was a kind of de minimis point raised, or that's been looked at, or that certainly none of these obligations have been held to be de minimis. Or
Why did the judge say it wasn't a repudiatory breach in that case?
I think he was talking about Mr. Textor's.
No, sorry, in the Grant and Sigmund.
Right.
What was his reasoning?
It was that it wasn't so fundamental as to go to the root of the contract. He said it. Let me get the reference. The page reference would be in our supplement.
The authorities bundle tab 7, page.
It says tab 7. It's page, the bundle page at bottom right 60, and then the page of the report is 416. This is it's not a fundamental breach entitling Mr. Sigmund to treat the contract with an end for 2 reasons. Then the first reason is the no cooperation point. And then the second reason, which starts at between D and E, that's what your lordship is referring to, is the that's the second reason. It's not a repudiatory breach.
No dispute about registration, so absence of the actual share certificate of formality.
Yes, and he goes on to say at G, non-production of the share certificates in this case on the dates fixed for commission does not amount to such an event, although non-production of the share transfers would have.
Yeah, I was reading from just below that.
Yeah.
So he calls it a formality.
It's perhaps also worth reading from G on page 59, the preceding paragraph.
So, as I say, my point is a different argument, and that argument brings different factors into play, which is how important was this relative to other things.
But he says it's just a formality, and what I'm wondering is whether if there's something which is just a formality, which isn't satisfied, does that stop the party saying they're ready, willing, and able to?
Well, we'd say it doesn't lie in their mouths to say it's a formality when it's one of the documents they have agreed they must provide. It's as simple as that. It is a contractual requirement that it be provided.
Was that not a contractual requirement in that case?
Yes, but there hasn't been in the trial a kind of investigation of all the ways in which a share certificate would or would not be significant and so on. We haven't really grappled with that. It's all just on the basis that it's in the contract, that you've got to deliver it. And you can't really say, well, you can't come along later and say, well, it's not very important. That's what you've agreed to deliver.
On page 55 of the report in that case, one of the contractual requirements was on completion, Mr. Sigmund will deliver and procure the delivery of the certificate for the shares.
Yeah. So all the arguments were just framed differently in this case. It was a summary judgment knocking out a repudiatory breach defence. So the whole host of all the arguments were just framed differently from the way they're framed in this case.
Well, I'm just wondering whether there really is such a difference.
Well, we say yes because you can't.
If you can say, sorry, let me just finish.
Yeah.
If you can say, if the innocent party can say, well, okay, maybe I'm not fully compliant with the contract, but it's a formality, as the judge put it in this case, or it's immaterial. Can't that party still say, for the purposes of specific performance, I'm ready, willing and able to perform my contract?
Well, that's not their case, and if they wanted to have that case, the burden would be on them to say, well, we couldn't actually perform all our obligations, but the ones we couldn't perform were trivial, and that's okay. But they never said that. Their case was they accepted that they needed to be ready and willing to perform their obligations under 3.2, which is to deliver those documents. They can't now
As I
say.
understand it, their case is that they're ready, willing and able to perform the contract.
Well, the primary issue is more specific than that. It's not just generally did you want to go ahead and transfer. It's were you ready and willing to perform your obligations under that clause?
Yeah, I think that's what they're saying. And the judge in this case seems to be saying it's just a formality, at least in a case where there's no dispute who were the duly registered shareholders.
Yeah.
But no, as I understand it, there's no dispute here that Iconic is the duly registered shareholder.
Yes. My submission is it's just a different inquiry here because he's dealing with a repudiatory breach argument where you can say, well, it was a breach, but it wasn't fundamental. And you can see why he said that, but that's not the argument we're having here. Well, also I've got to move on to my last topic, if I may, which is Premier League approved or regulatory approved. It's an important topic. And I've broken this down into seven steps or 7 points. There's been quite a lot of discussion in the skeletons about it, but I've tried to break it down to 7 points. The first is that they were the ones coming to court with a positive pleading that they were ready and willing to perform their obligations on the repayment date. That's paragraph 41(1) of the particulars of claim. And as you've seen in the skeleton, so that's their case. We were ready. And one of the points made in our defence of paragraph 32(b), quoted in the skeleton, was to the best of Mr. Textor's knowledge, Iconic failed to take any steps to verify whether consent was required from any football authority under 13.1 of the shareholders agreement and or to obtain such consent. So in a sense, the battle lines were them saying we're ready and us saying, well, how can you say you were ready when you never even thought about any of this? That was our point. And 13.1, the shareholders agreement, is at page 175. This is referred to in both skeletons and in the judgment. So page 175 is the shareholders agreement for the company. And it's a prohibition on a shareholder transferring shares in the company until all applicable consents, clearances or approvals required from any football authority, including without limitation any consents or approvals required pursuant to the Premier League rules, have been obtained. So it's a prohibition saying you can't transfer the shares until those have been obtained. Now, that prohibition, the point that's really thrown up by the skeletons is this, that prohibition, they wanted to transfer their shares. And that prohibition would apply even if the consents or approvals had to be obtained by someone else. Because you are prohibited from transferring your shares unless the approvals, any necessary approvals and so on, have been obtained. So let's say you're in a scenario where it's Crystal Palace, the club, who has to go to the Premier League and obtain consents and approvals. Until they've done that, you as transferor can't transfer your shares without breaching that prohibition. So my second point really is that there is this clear prohibition, and it's not an answer for them to say, well, this is other people's problem, because the prohibition applies to them as transferor. So they can't distance themselves from all of this and just say, well, it's totally irrelevant to us, as they seek to do in their skeleton. They were bound by that prohibition, even if it was other people who had to do the running and obtain any necessary approvals or clearances.
If this was right, they'd have had to do this at the time of the option agreement, wouldn't they? If you're right about this point.
Well, you could argue that. I don't know.
Well, it
It's
says it, or granting the option or other rights over any of the shares.
No, I see what you mean. Yeah. But certainly the transfer, it would bite on a transfer.
But no one thought it was a problem when they entered into the option agreement, it seems.
Well, we've now found, in response to what they've said in the skeleton, the email from the chairman of the Premier League saying that it was all approved on the day these agreements were all entered into. So, in a sense, what we're saying before your lordships is that they can't just wash their hands of all of this.
But if that was approved, does that not then cover a transfer pursuant to the option?
We don't know.
Oh.
I'm afraid we're in an unsatisfactory position with this having happened so quickly that these matters were not fully investigated. And in their skeleton, they've said on the day when they entered into the documents that they've asserted as a fact that the parties didn't seek approval. And in response to that, we found an email from the chairman of the Premier League on the same day as the put option was entered into, giving approval. So it hasn't been, we haven't fully investigated. The point your Lord is making is, did that approve in advance the transfer of the option shares? I can't pretend that this has been gone into or that anyone here knows the answer. And in a sense, all we're saying is they had to take this seriously. And if they were bound by 13.1, and if they were seriously getting ready to perform, they would have had to raise this and discussed it with all the interested parties, including Mr. Textor.
This is just Premier League in relation to Crystal Palace, yes?
Yes.
That's the relevant authority.
Yes, although there were other clubs in the structure.
There
There's
were,
Brazil.
but it's the Premier League you're focusing on.
Yes, although the point applies more generally in the sense that this is taking place in a complex, regulated environment with multiple clubs. And we're not saying that we didn't go into the trial the rules of the Brazilian, or even really but the point is you have to consider it if you're seriously getting ready to perform. It's not something you can just brush aside and say, well, that just doesn't matter.
I mean, the first question is, was any approval needed from a particular authority? The evidence on that is at the moment only related to the Premier League. Is that right?
Yes.
So it's not at the moment. You're not at the moment in a position to say they failed to get approval from some other regulatory body.
No. No.
So we are only concerned with the Premier League.
Yes. Although the point is, in theory, more general in the sense that in that situation, someone getting seriously ready to perform would have to address their minds to the regulatory context more generally, and they didn't do that. It seems to be accepted as a matter of fact that they did nothing to explore or anything else regulatory with Mr. Textor prior to the completion date.
But I mean, is that very surprising? As I understand it, they'd got prior approval of the option agreement itself, and the transfer of shares involved Mr. Textor moving from a 65% owner to an 80% owner, so that they were hardly likely to be worried about that if they were happy with him as a 65% owner. All the references to what might happen if Mr. Textor was not involved, and the Russian connections and so on, doesn't arise, does it?
Well, it's more complicated than that, because under this structure, they might get control under clause 5 of the put option agreement. They might get control over Mr. Textor's shares, and there's the Aries point dealt with in Mr. Textor's evidence that the balance of power at the company can change as the Iconic investor directors depart, leaving the Aries investor directors with this enhanced power over significant corporate action. So it's got a number of dimensions.
But that arises if and when the clause 4 rights are exercised. Doesn't arise out of the completion of the put option itself, does it?
Well, they can't transfer the shares unless they've got their ducks in a row under 13.1.
Well,
And
park that for a moment, but assume that's right,
Yeah.
and that compliance with the shareholders' agreement is itself a condition of compliance with the option agreement inquiry. But assume that is right. The question that arises is, did they need actually to seek approval in this case from the Premier League to make Mr. Textor an 80% shareholder rather than a 65% shareholder, against the background that they had approved him as a 65% shareholder of the club effectively, and that they'd approved the put option?
Well, his evidence
Is that the right question?
Well, in a sense, we did not go to the trial with a positive case that we could prove that some particular approval was required. And you've seen that referred to in the judgment. The judge records that. But our point was a different one, which was, as I've said, any party seriously getting ready to perform would have addressed their minds to this, would have taken advice, and would have started a dialogue with the other stakeholders. And the fact that they didn't do that shows that they were not seriously getting ready to perform.
Isn't the burden on you here? I quite understand that if we look at the specific matters that are required by clauses 2 and 3 of the put option agreement, the question is, are they ready and willing to perform that? But if you say that because of the terms of the shareholder agreement, there were other things that they had to show they were ready and willing to do because they needed Premier League approval, isn't the burden on you to show that they needed Premier League approval? And if you didn't, you weren't in a position to prove that, you can't prove that there's something that they needed to be ready and willing to do in relation to that aspect of performance.
Well, we would say it's their case that they were ready. And we challenge that on the basis of how can you be ready when you haven't addressed this?
But they can be ready without addressing it if they didn't need to address it.
Yes, well, I understand, but the evidence at trial for Mr. Textor himself, who's an experienced football owner, was the Premier League would have wanted to look at it, and it could have taken weeks.
But I think that's on the hypothesis of Iconic and Mr. Textor ceasing to be directors, and therefore
No.
No?
It was on the hypothesis that the transaction, the share transfer in the put,
Yes.
was going to happen, and they would depart, changing the position of the company.
But how would the Aries problem arise in those circumstances if Mr. Textor was still the 80% shareholder?
Because there's a group of investor directors which, before they depart, includes them. And the investor directors have got important rights under the shareholders agreement. And when they depart and cease to be directors, then the Aries investor directors are left as the only investor directors. This was the point that Mr. Textor referred to that's in our skeleton. And they then have on their own these very significant powers under the shareholders agreement.
Wasn't Mr. Textor left as a investor?
No, he's not an investor director, he's a director. So there are, he was very clear in his evidence that his view as an experienced football owner was that it would be required. And in a sense, they are just saying now, well, it's not our problem. We didn't have to even think about it because we could have just gone ahead under the put option agreement, even if we were in breach of 13.1 of the shareholders agreement.
But you don't have a finding of the judge on that question.
Well,
I mean, do you need one?
no, I mean, I'm just saying that it undermines their case of readiness in a significant way that they did not address their minds to this at all. And they're now saying in their skeleton, it's just not our problem, other people's problem. It doesn't matter if the clubs were subject to regulatory sanction, not our problem. They say they could just walk away by selling under the put, and then it didn't matter if they were in breach of 13.1. We don't accept that.
Can you just just dot the I's and cross the T's for me in terms of how you say it works. There's the provision in 13.1,
Yes.
which is a restriction on what shareholders can do between themselves. And do you just simply say that you just rely on that as a freestand? You don't say that has any embodiment in the put option agreement itself?
Two stages. I mean, firstly, just looking at 13.1 in isolation, anyone proposing to transfer shares in breach of that could potentially be injuncted if that was going to cause significant damage to the interests of the company. So that's the first part. The second part is that 3.2b of the put option agreement at page 139 says that this is their completion obligations, and that they shall do such other acts and things and execute other documents as shall be necessary, I miss out those words, to give effect to the sale of the option shares on the transfer terms. And we would say, in response to the points made in their skeleton, it's got to be implicit in that you have to carry out a lawful transfer of shares in accordance with the shareholder agreement and the articles. They're saying they're totally independent, and it doesn't matter if you're breaching the shareholders agreement. You can force that transfer to go ahead. And we don't accept that point that they've made. As I say, that's both a question of what the put option agreement means and a question of what would have happened in the real world if someone had tried to go ahead with a transfer that could cause significant regulatory damage to the clubs. Firstly, you'd have an argument for injunction to stop that happening because it would be a breach of contract. And secondly, how could people who are directors of Eagle, as Mr. Nastor and Mr. Deenan were, force that through in circumstances where it was going to damage the company? So all of that really goes to something, to the central thrust of the point, which is that they just had to address their minds to this to get ready, and they failed to do so. And you've seen the point I mentioned earlier in our reply skeleton. We've dealt with those factual assertions that they made in their skeleton, that no approval was sought when these documents were entered into, when they were amended. And we've produced 3 documents in relation to that to show that those assertions don't appear to be correct, although no one can pretend that we've fully investigated that issue in the context of these proceedings. So those were my submissions. I think hopefully I've managed to save at least some tiny amount of time for reply, and that's all I was proposed to say.
Mr. Wynne, I think we might just rise for a moment to see where we are.
Court rise if able. Court rise if able.
Mr. Green, we don't need to hear you on ground 1. We'd like to hear you on ground 2, please.
Well, of course, it would be very easy for me in those circumstances to say that Mr. Perkins was going to deal with ground 1, but that would not, in fact, be quite correct. So I come clean right at the outset.
Right.
So dealing with ground 2, in giving permission to appeal on ground 2, my Lord Justice Phillips expressed the view that it's sufficiently arguable that in order to be ready to comply with its obligations under 3.2, Iconic had to be in a position immediately to transfer the shares. And my learned friend's skeleton of paragraph 50 advances that proposition. It's about immediacy. So the first issue under ground 2 is whether Iconic had to be ready in the sense of being able to make this immediate delivery, as my learned friend contends, or whether it had to be ready in a rather broader sense of being able to make delivery on the repayment date, as Iconic contends. Now, this is an issue of construction of the provisions of the put option agreement. The case law is instructive when we say helpful, but ultimately it is a question of construction. And once the question of construction is answered, there is of course the factual issue as to whether Iconic was indeed ready to do what it was contractually required to do, and the judge's findings in that regard. I should make clear that there is no dispute that Iconic was willing to perform. That was a dispute, as I understand it, below, but that's no longer a dispute. It's not challenged by my learned friend that we were willing to perform. So the sole issue is that of readiness, and it is common ground that the issue of readiness is essentially one of ability. And that's set out in our skeleton at paragraph 47, and in my learned friend's reply skeleton at paragraph 16. So we agree that that is the correct test. And so the factual issue is just simply whether Iconic had the ability to perform on the 26th of July 24. And on that factual issue, importantly, it is not suggested in either of my learned friend's skeletons that Iconic would not have been able to deliver the relevant documents during the day on the 26th of July 2024. Nowhere in his skeletons does he say that. So he's got no positive case, either in respect of the share certificate or the power of attorney, that Iconic would not have been able to deliver the documents on the 27th or 26th of July. His case is purely that Iconic's obligation was to be ready to make immediate delivery, and it couldn't do that because it hadn't pre-prepared the documents. That's certainly the way his case was presented in his skeleton. And so
I haven't understood that to be their case.
Oh, well, my lord.
I thought their case was that they couldn't deliver the documents on the 26th of July, but I may have...
Sorry, did I not say? Yes, but we needed to do it immediately. And we'll come... Well, we're going to come on...
It doesn't mean by the end of the day.
Well, I'm not. That's one of the points that my learned friend hasn't addressed anywhere in his skeleton argument. What exactly he means by immediately? Does he in fact mean at 12:01 a.m. on the 26th of July, or does it mean immediately when a completion meeting takes place and Mr. Textor is available to make payment? He hasn't grappled at all with what it means to deliver immediately, and that's one of the slight difficulties. But
I'm so sorry to be...
Of course.
To follow this up, but the question was whether... What was the preliminary issue? Is whether they were ready, willing and able on the
day, repayment date.
That means at all times up until midnight on the 26th of July, doesn't it?
Yes. And certainly the way we had understood my learned friend's skeleton and his appeal is that what he meant by immediately was that we had to be ready from the moment the 26th of July hit, so effectively at 12:01 in the morning. We had to be ready to have the documents because we pre-prepared them and we were ready that day. If I'm wrong on that, I don't think it makes any difference to the analysis we're about to go through in any event.
Well, that's not the case that's been advanced already.
No, it isn't. I mean, immediacy has the word immediately has not featured very heavily, but certainly that was the way it was presented in his skeleton, and certainly that was that appeared to us to be the basis on which permission to appeal had been granted. But as I say, I don't think it matters because the first issue, one way or another, is construction. And the key question is, what as a matter of construction was the delivery obligation that day? And so if I can just start with the construction point, there is certainly nothing in the wording of the put option agreement, particularly clause 3, which supports the propositions that my learned friend has been advancing, that the correct position is that the parties' obligations were to perform on the repayment date without any further requirements being specified. So if we just go to the core bundle and the agreement itself at page 137, we look at the definition of repayment date. It has the meaning given in clause 2.3. Then in clause 2.3, it's 12 months from receipt of the option notice. Then in clause 3.1, we see that it's on the repayment date. And then clause 3.3, on or before the repayment date. And 3.4, it's on the date agreed for completion. And then if you just look at clause 4.1, it's by the repayment date. And so everything points to the parties' completion obligations having to be performed on the completion date, which will be a date to be agreed, failing which it's the repayment date. And that this, of course, presupposes that Mr. Textor will participate in the completion process by agreeing in advance to attend or by giving reasonable notice of his readiness to comply, even if that is on the morning of the day. So the obligations, the completion obligations, have to be performed on the completion date, subject to realistic notice having been given by Mr. Textor, which was effectively the point that my Lord Justice Popplewell was making.
And for your part, you accept that realistic or reasonable notice need be no more than the morning of the day?
Yes, I would accept that. And I think what I would also say is that this contractual framework clearly contemplates that there will be at least a minimal level of cooperation between the parties to agree the completion mechanics, the when, the where and the how. And we see that from various of the provisions, but it's blindingly obvious. And of course, in section B of our skeleton, we set out the chronology, which shows Iconic repeatedly asking Mr. Textor to explain his plans for completion. And he totally ignored every communication because he didn't have the money. And then on the 15th of July, he made it clear that he wouldn't be paying. So there was one party, Iconic, trying to deal with the mechanics of completion so that it could comply with its completion obligations. And the other party, Mr. Textor, was simply refusing to engage. And it would be uncommercial in those circumstances to construe the contract's completion obligations in such a way that they required Iconic to be ready to tender documents immediately, at a moment's notice. If, for example, Mr. Textor, having said what he said on the 15th of July, simply phoned up from the Beak Street offices, says, I'm here, I'm ready to pay, what's happened? That's
Well,
just
I think that's where Mr. Davis ended up.
Yes, and
I'm
we say
not
that's
sure that there's anything between you now on that.
well, except that I say that is a totally and utterly unreal construction of what this contract requires.
No, sorry, I thought Mr. Davis ended up that it was a question of readiness had notice been given to the extent of notice on the morning.
At least on the morning.
At least on the morning.
Exactly. Exactly. I mean, I should just say, it is a consistent theme in my learned friend's skeleton that Iconic failed to take steps in advance of the completion date to get the various documents together. Now, I mean, again, that's totally unreal in circumstances where Mr. Textor had refused to engage with discussions about completion and made it clear that he wasn't going to be making payment. So it can't sensibly be suggested that Iconic was contractually obliged to go through the charade of physically getting documents together for a meeting that was never going to take place and hadn't been arranged.
Well, that may be a sensible commercial approach if what one is looking at is whether you were ready, willing and able to complete at the date you're asking the court to order specific performance, which on one view of the law might possibly be the relevant time, but that's not the time that was fixed by the agreed preliminary issue. And the agreed preliminary issue is ready and willing at the date, at the repayment date.
Yes.
And on that analysis, it is, isn't it, a question of whether you were ready on that date, whether or not, if in commercial terms you'd all be going to go ahead, you might have had some advance notice and been able to investigate the position at an earlier time.
Of course, but the question, the factual question, is whether or not we had the ability to provide what needed to be provided during the course of the repayment date day.
Yes.
That's the sole point I'm making. What we didn't have to do was we didn't have to be ready with the documents available. If Mr. Textor suddenly phoned up on the day and said, right, I'm ready, I'm waiting at the office, I want the documents now. 10 minutes later, he phones up and says, you're in repudiatory breach.
Well, that's been myself. I'm not sure there's anything between you on that.
No.
Now,
exactly.
if that's your point.
No, that's right. So the sole question then is the factual question.
Right.
What was the position? Did we have the ability, as at the repayment date, at some time on the repayment date, to provide or to comply with the obligations? And I don't know whether, I mean, that now brings me to the judge's findings. I don't know whether you would like to break now or whether I should carry on for a few more minutes.
That may be a convenient moment. 2 o'clock.
Court rise available.